Okay, Jacqueline, I just want to check if you can hear me on your side.
Yes, I can. Good morning, Vaughan.
Excellent. Good morning, ladies and gentlemen, and welcome to another Nova Labour Law Chambers session. I'm Vaughan Botha, and with me I have Jacqueline Azel, that is dialing in from our Cape Town offices. Jacqueline is an accredited mediator, which has been an invaluable skill in facilitating large retrenchment consultations and conciliations. But apart from that, we've identified some of the mediation tools that in our experience, we believe that can add value to your internal counseling process. We will provide an opportunity for questions afterwards, but please feel free to use our Q&A functionality. And for those that weren't able to attend the session, we will also be posting a recording of the session on our YouTube channel. So please go ahead and subscribe to those channels in order to be updated accordingly. So what we're going to be dealing here today is we're going to be laying a foundation for our second session, which is going to be next month, and which would deal extensively with poor performance. But what we've seen as Nova is probably about a 300% increase in incapacity cases over the past 3 years. Incapacity being poor performance and ill health. And although it is not statistically backed, we do believe that the COVID pandemic and the aftermath after that has a significant effect on our workforce today, as well as our executives. And what we've seen over the past few years is our clients are very well versed with disciplinary processes. So they understand how to apply corrective disciplinary action, how to issue warnings. They understand what forms of misconduct are serious enough to initiate disciplinary procedures and which constitute possible dismissible offenses. But what we've seen is that many companies and many people that are mandated to be dealing with these forms of workplace conflict don't understand how to deal with those softer issues and workplace conflict that Jacqueline will be dealing with today. What we've further seen is that the employment relationship is very much a reciprocal relationship between the two parties. And what is severely hindered the resolution of these conflicts in our views over the past 2 years is either of the two parties not participating in it. And you will very much know, and Jacqueline, I'm sure you will agree with this, that the employment relationship is very much a relationship. And if there is workplace conflict or conflict in that relationship, both parties have to have the appetite and the willingness to engage to try to resolve that conflict. Does that resonate with you, what I've said, Jacqueline?
Absolutely, Vaughan. Yes, I can't agree with you more. I think the balance has shifted a lot in my desk recently if I look at misconduct versus counseling sessions. And in those counseling sessions, a lot of what you've already mentioned is true. Incapacity due to ill health, absence from work. Like you've already mentioned, we'll look at the poor performance incapacity scenarios in another session. And yes, indeed, conflict is the root cause of a lot of the problems. And I would like to today share with the audience a few of the mediation principles that I have brought into more the legal realm in the workplace. As a lawyer, we tend to want to almost punish more, but as a mediator, we want to conciliate more. Nice. So indeed, what we also see at the CCMA is there's a much bigger pressure on commissioners to try and keep people in jobs. How does this tie in with our topic this morning? I want to share with you the value of building in that extra layer, the counseling layer, so that by the time, if unfortunately we do end up at the CCMA from time to time, then you can really show you have tried everything. The role of counseling is sometimes either confused or overlooked in the sense that we tend to think of progressive discipline as possibly starting with a warning, a verbal warning, or for the more serious things, yes, first time round, we might issue the written or the final. But a counseling is actually the first step of progressive discipline. Like you've already mentioned, Vaughan, there's a relationship And one of the principles that I'll highlight further a little bit, the beauty of counseling is by law, employees are actually obliged to participate. It's not optional. They have to participate. So,
excellent.
Yes. Yes, like I've said, the beauty of counseling, I really love bringing the principles of mediation into the counseling sessions. I found that it is a lot more effective and we really reach good outcomes when we incorporate some of these principles. So in essence, a counseling session is a structured conversation where a facilitator, like for example myself or another practitioner, facilitates the conversation between the employer and the employee. I would typically start off the session by introducing myself and to explain to the employee that I'm going to try and assist the parties to talk about a specific issue. And a lot of what we do at this stage is absenteeism, ill health, lots of sick certificates coming through. And then I'll explain to the employee, the employer is concerned about your attendance at work. I'm going to ask the employer to give me a little bit of a context, you know, how long you've been in the business, you know, how many sick days have you taken in this cycle? And then I'll say to the employee, and I really love hearing from you, perhaps you can provide some information that will help us, because ultimately, what do we want to do in this counseling? We want to improve the situation. We want to know how the employer can support you. So a counseling session is where we want to share information and we want to make plans, positive plans to improve a situation. So it's informal, but it's got structure, and it's the facilitator's role to guide the parties. I must say it seldom gets heated in an absenteeism type scenario. It's more a question of sometimes the employee would just clam up and say, well, I don't have any suggestions. But it's the facilitator's role to manage the parties and to ensure that there's a flow of information. The difference then between a hearing and a counseling from the perspective of the facilitator or then the chairperson. If you facilitate a counseling, you participate, you can make suggestions, you can even share your opinion to a certain extent. You know, you can stick your neck out in a sense to say, you know what, are you really going to try and convince me that you're healthy, but you've used 30 days in 12 months, you know? Whereas a chairperson of a hearing will not do that. You will only listen to the evidence and you will adjudicate or make a finding at the end of the process. Important on the same aspect is the impact on the employee. A counseling doesn't have the same black mark behind your name. If you're found guilty and you get a warning, that is on your record. Whereas a counseling is something that is supposed to be helpful and it doesn't have a negative impact on your employment record. For the employer, a counseling is very easy to prepare for if you've got your payroll systems in place where you log everything, then you can literally draw a report. We are in this sick leave cycle, the employee has used so many days, this was for sick, this was family responsibility, this was unpaid, or this was annual leave. So it's easy to draw that report. Why is it also easy for the employer? Because you don't have to prepare witnesses, notify, prepare document packs. I try and structure my counseling sessions for our Nova clients as something that's an easy to use tool for the employer. It's my job to jot everything down and to send the notes or the little report. But it should be something that you make easy for your client to quickly schedule a counseling session, draw the report, come into that session, and then there's your paper trail. So the impact on the employee is limited when we counsel, and it's supposed to be a fairly easy process for the employer to prepare for. My Brownie point principle is the one that I really like. And when I said you can sometimes stick your neck out a little bit in these sessions, I even go as far as to say to the employee, you know, I go to the CCMA often. And what I most enjoy is when the commissioner asks me, Mrs. Azel, Did the employee know that they could possibly end up being jobless or end up with a warning? Then I can say, yes, Commissioner, the employee knew because I told the employee and I explained to the employee. What is the other brownie point? If you can say, Commissioner, you know what? The Code of Conduct actually allows for a final written warning for a first offense of abusive sick leave. But you know, Commissioner, people have been struggling and we're cognizant of all the pressures that people experience. So we actually had 2 counseling sessions prior to issuing the first warning. So your counseling sessions is a very easy tool that has a lot of positive spin-offs. Like we alluded in the introductory remarks, if we didn't experience conflict, we wouldn't need facilitators, we wouldn't need chairpersons, we wouldn't need these forums where we sit around the table. So when we deal with people, we'll always have conflict. Why? Because people have different viewpoints, people believe in different things, people add different values to different aspects of their lives and balance things in completely different ways. So as a facilitator, when we go into a counseling session, it is important that you are able to identify the source of the conflict and then to try and explain to the parties how best they can manage to find a middle road, like a golden midway between the different standpoints. So if we look at the different forms of conflict, I'm going to leave relationship conflict for last. Let's start with, I just want to do that. Let's start with values. What do we think of when we talk about values? Something that we all, I think, up to here with is vaccination. Mandatory vaccination. Who's going to implement this? Who's not going to implement it? Can I be forced? We saw a lot of conflicting views where one employee's value might be, according to my religion, I'm not going to vaccinate. That's my values. And then the employer says, but it's my workplace and I feel for me to create a safe workplace, I'm going to implement this policy. So that's an example of where values can cause conflict. Or cultural conflict. In certain cultures, females are supposed to stay home and cook and clean. They're not supposed to work. They should definitely not be in management positions. So now maybe there's cultural conflict in the workplace because there's a female manager overseeing possibly a group of males. And one of the males might not appreciate having to report to a female manager. So that's an example of where, for example, culture or religion can cause conflict. Interests. It's a difficult one. I had a while back, a couple of years ago, a scenario at a factory in Atlantis where this employee was routinely off on a Monday, booked off. When we started talking to him, it transpired that he plays club rugby on a weekend and usually he's a bit botched up. So he goes to the doctor on a Monday, he's too sore to work and he's booked off. So his interest lies with his club rugby. The interest of the client lies with running a factory with a machine operator that reports for duty regularly and reliably. So I had to explain to this employee, well, you need to decide what you're interested in more. Are you interested in your job or are you interested in playing club rugby? But you are expected to be at work. So you're going to have to think about this long and hard. Data. Once again, I love these counselings and I love these reports that the HR people can pull out of their systems. It's very helpful. Sometimes the employee would sit in these sessions and they would be of the view that their absenteeism is actually quite okay. They're not that sick. And when you confront them with the data, you can show them the numbers. Not show me the money, show me the numbers. Show me the days. Show me the patterns. And when the employer in these sessions plot out, first instance, Monday and Friday. Second instance, Thursday, Friday. Third instance, Thursday, Friday, Monday. Fourth instance, before the public holiday. Then the data that you present can show this employee that you are in the wrong. Structural conflict, we find a bit more if we talk about ownership and control. We can bring it into the normal employer-employee relationship, but it's more in your civil commercial environments where we get more confronted with structural conflicts. But essentially, it's the role of the facilitator to say, this is possibly why we have the conflict and how are we going to move around this and make it better? How are we going to move past this? Very important, the facilitator you use should have a good body of knowledge. Legal knowledge, people knowledge, negotiation skills, because it's also at this point where the facilitator would sometimes have to explain legal, technical things to the parties to say, yes, you might have a right to your sick leave, but the employer has a right to run a profitable business that functions well, where we know people are going to come to work regularly and reliably. So we need to strike a balance. Often people will tell me, but I have a right to privacy. I don't have to share my medical information with the employer. Then I would immediately be able to point out to that employee, yes, you've got a right to privacy, but do you know that there's a limitations clause in the Constitution? That means no right is absolute. So you have to help us in this session balance your right to being booked off sick with the employer's right to run a profitable business. So the quality of your facilitator is very important. I'm a big fan of the polygraph, for example. The test is wonderful, but your examiner, the skill of your examiner and the quality of the equipment is important. Same. Counselings can be very valuable, but the quality of your facilitator is going to play a key role in how successful this tool is. So talking about the facilitator, the role of the facilitator is to balance power. In the world of work, we have this disposition where somebody's in charge and somebody's reporting. In Afrikaans, I can say die baas in die klas. So in the facilitation of this counseling session, it's important that the facilitator makes the parties understand and experience that I'm leveling the playing field. It's not about who I like. It's not about my personal opinions. It's about what does the law tell us? What can we do and what can we not do? And that's why I'm saying the knowledge of your facilitator is very important. I cannot, in the middle of a facilitation of a counseling session, say, ooh, I must actually quickly go and see what did I learn in my second year of my law degree about contracts. No, I must immediately be able to tell the employee, you know what? The moment you sign that employment contract, you basically told the employer you're going to come to work regularly and reliably. So you've got contractual obligations, and we need to see how are you going to fulfill those obligations, because at the moment the picture looks a bit bleak. All right. It's the role of the facilitator to help people to create self-awareness. It does sometimes happen where once the data is plotted out in front of the employee, I've had situations where the employee told me, you know what, I actually never realized that this pattern exists. You know, and they're honestly shocked, and they realize, or they didn't realize that they basically off sick every month for 2 to 3 days. So it helps the employee to gain an understanding in their own habits, because sometimes people don't realize this. Or the employer doesn't realize how they talk to people. Sometimes the employee would say, listen, but you know, I actually don't feel like coming to work because, you know, whenever I raise my hand to ask a question, you know, I get barked at. So sometimes other things come to the surface in these sessions, and it helps both parties. But like Vaughan said at the onset, for this process to be successful, both parties must be willing to walk the walk and talk the talk and take this forward in a positive way. Personal growth, organizational growth will then stem from understanding yourself better, understanding how to speak to your subordinates better. Or the employer might become more aware of certain challenges that employees face. Not everybody is as aware of what goes on in the news. I mean, a while back, we had a lot of taxi violence. So some people could physically not come to work. So some organizations have made plans. I mean, I've worked with one of our clients where at the time they even organized inner city accommodation for their staff so that they didn't have to travel back to those areas where the violence were and they could still come to work. So some of these processes are really literally heartwarming, where you see people meet each other halfway, take each other's hands, and really come out with something very positive at the other end. So it's the facilitator's role to arrive at and help people solve problems. It's not a magic wand, especially not if you deal with chances. We also have situations where people really take chances, where they lie. I literally yesterday had a session where the employee admitted that, you know what, I wasn't really sick. I just didn't feel like coming to work. So you get the chances as well, but ultimately it's then your job to say, well, if you're not going to change this behavior, you might end up without a job. Sometimes I really enjoy being rather the facilitator than the chairperson because I can more freely speak my mind. And I'm going to just share with you a little portion of what I sometimes read in these sessions, or I can do that a little bit later. But you need to make the penny drop, to put it plainly. The penny needs to drop for that employee, and the employee needs to understand, yes, I've got my rights, but I've got responsibilities. The employer must pay me when I'm sick, if it's paid sick leave, but the employer can also expect certain things of me. So it's your job to strike that balance for the parties based on what we are legally allowed to and expected to do. Ultimately, we want to create a sense of, we want to support you, we want to help you, so that at work we can function as a team. That's ultimately what you want. It's not a punishment session. It depends on the attitude of the employee sometimes, how it turns out, but ultimately it's not a punishment session. So in reality, what spin-offs do we get when we have these counseling sessions? We're building a record, we're building our paper trail. Sometimes the employee is a little bit taken aback when I say, I'm going to be sending through my notes and it will go on your record. And then they say, but is this a warning? No, it's not a warning, but it keeps people accountable. So if you committed to bringing the employer the report that you said you're going to bring, if you committed to bringing your appointment card for your next month's clinic visit so that we can roster accordingly, then I'm going to jot it down. So if we have a check-in session in 6 weeks' time, and the employer tells me, but we still don't know when you come and when you go, then I can say, but you committed to bringing your employment card. Why didn't you? So it protects people. If the employer told me in that session, yes, I'll definitely do the managerial referral for the employee to the counseling service. If we sit in that session again and the employee says, but the manager still hasn't made that referral for me, then I can hold the employer accountable. So we build a record. It protects both the employer and the employee, and it's one of our brownie points if we need it later on. It's an opportunity to investigate and discuss. Like I said, sometimes we sit with a person where what we see is absence, absence, absence. But when we sit in the session and the employee starts sharing what they actually experience in their personal life. I recently had a session where the employee disclosed to me that she was raped a couple of months ago. That as a result of that violent rape, that is why she's now having the pelvic problems, where they're trying to help her and she has to go back to government facilities. So It just puts everything in a completely different perspective. And then there's an understanding, and the employer can then know, how can we support this individual? And more importantly, we are supposed to accommodate that individual because it's a genuine situation. In reality, reality check. Like I said, it's the facilitator's job to make that penny drop. And here I just want to share with you, it's a little bit unorthodox, but I routinely share this piece of legal writing with the employees, especially if they refuse to understand their obligation to come to work. And if they tell you, but I always bring a sick certificate. Sometimes employees tend to think that if the sick certificate is there, anything goes, they can get away with murder, they can take 50 days sick, 30 paid, 20 unpaid. It's like there's no end. Then I share with them the following, and it's from the esteemed writer John Grogan. And then I read this. This is part of my most important reality check for employees. And I'll share with you, it says, generally, dismissal is not warranted for an illness or injury that results in relatively brief absences, except if the absences occur frequently. And then I'll say to the employee, like in your case, you're sick every month or you're sick every 2 weeks. Then I carry on and I'll read. Many companies have absence policies that provide for dismissal for repeated brief absences, even if they are occasioned by different illnesses or injuries. I just want to pause here for a bit. Sometimes employees think you can only end up in an ill health incapacity process and possibly lose your job if you were in an accident and you now paralyzed, or you lost your sight, or you lost a limb. Then only do we talk incapacity, ill health. That's not the case. And I share with them further. It says, the courts have held that dismissal is in principle permissible in cases of repeated absences, even if they are for medical reasons covered by medical certificates. In such cases, employees must still be counseled and consulted. And then I say to the employee, and that's what we're doing now. We're counseling you and I'm consulting with you. So please share with me what suggestions you have for us to change the situation, because it has to improve. So your reality checking in these sessions are very important. I've already mentioned that in these sessions, we sometimes uncover that there are other reasons why people don't come to work, or other reasons why people don't perform. And once you're able to support them with a real problem, it might be a family problem or a psychological problem, again, the performance will pick up to where it used to be. So we gather information, we share information. You can't force people to share, but then ultimately you'll work with what you have. I once had a session where the employee sat back, he crossed his arms, and he told me in Afrikaans, my woorde vir vandag is op. He said his words for the day is finished. So I said to him, then I'm going to have a really tough time trying to help you. So you can also only bring the horse to the water. You can't force the horse to drink. Jy kan die perd na die water toe bring, maar jy kan hom nie maak drink nie. So you can only work with what you have. And again, I want to go back to how important it is who you choose to use for these sessions, because your facilitator must be able to adapt to what plays out in that room as it plays out, and to respond to what they get. Sometimes you get a very aggressive employer, and then you must be able to tone the employer down and say that this is not a hearing. We're not accusing anybody of anything. We're here to find out how we can help. All right. Ultimately, when we have these processes, we minimize risk. And you'll hear when we have our session specifically on incapacity poor performance, you will not have a procedurally sound incapacity process unless you have counseled. So in some instances, having counselings is a nice to have, it's a luxury. In other instances, the law requires of employers to have counseling sessions. And it's not a tick box exercise. One counseling session might not even be enough. Depending on the situation, a commissioner might say, but you should have done more. All right. I've already emphasized joint effort. It's a team effort. Everybody needs to buy into this. Otherwise, you can only go so far. So your role in a counseling session, remember, you're not an adjudicator. You're there to facilitate a constructive conversation. You're not the decision maker. And that is something that we often hear at the CCMA, where the commissioner would say in the conciliation phase, I'm not going to rule anything. The parties, the ball is in your court. You must decide how this can possibly be resolved. Because if we move past the conciliation phase and we get to arbitration, yes, then I'm going to decide how this ends. But at the conciliation phase, or in a counseling where you facilitate for the parties, you're not going to decide what happens. A successful facilitator should be able to get the parties as far as making suggestions, making commitments, and you will only remind them of what they have committed, and you will jot that down in your report. But ultimately, you must, without them knowing, guide them. It's almost like when you work with children. If you want your child to choose a particular thing, there's ways where you can make the 3-year-old not want the green cool drink at 5 o'clock and rather want the fruit juice. So the skill of your facilitator is important. You're a participant, so you can share a bit more of your own views. You are the specialist. So it's also your job to correct parties if they have misconceptions. One of these misconceptions that I come across often is where the employee says, oh, I know my sick leave is depleted, but I just take unpaid leave. You know, it's not costing the employer anything. Then I say, whoa, stop the bus. You might not get paid for that day, but in a lot of industries, when you are not at work, let's say, for example, in the call center environment, a collections campaign, when I have less advisors on the dialer, I take less calls or I make less calls, and I get less money in on that day. So yes, when you're not at work, you are costing the business money because you are not on the collections campaign collecting. You're not helping us work towards that target. So you might not get paid, but you're still costing the business money. As a middleman, you must show understanding. You must show compassion where it's necessary. Again, I'm not saying that a 22-year-old doesn't have a lot of knowledge, but the more experienced your facilitator is, the more understanding that person should have about what life is about, what the world of work is about, what it takes to sometimes balance all the different aspects of our lives. Home life, children, in-laws. I live in a township. There was a flat. My transport didn't arrive. You must be able to show that you can at least have an open ear to understand what this person is experiencing. Why are they having these difficulties? The facilitator will know how to strike the balance between listening and talking. If you're in a session where the employee is quite forthcoming, you'll do less talking and you'll do more listening, and you'll learn a lot probably. If the employee is one of those whose words for the day is finished, you're going to do a bit more talking. You're going to try and get some more information. You might even read from your Grogan to the employee to say, listen, you're supposed to participate. And if you don't participate, we're going to work with what we have. So I'm going to ask you again, do you have any suggestions? Do you need any support? Are you aware of anything that we can assist you with? All of those things goes onto your record. So you can show this person had the opportunity to say what they need. If they don't say what they need, how should the employer support them? All right. You negotiate. And like I said, if you're a good facilitator, you should be able to get those parties to make certain commitments. And then depending on how serious the situation is or how bad that picture looks, I routinely already get the parties to commit to a check-in session. If I work with absenteeism, I usually give an 8-week cycle. An 8-week cycle is a nice cycle to check. It's 2 months, and we can see what happened in the 2 months. Also, we'll talk more about the poor performance. Very important when we look at poor performance, your counseling session is there to alert the employee to the shortcomings. They must have a reasonable opportunity to improve, and they must understand the possible consequences if that improvement doesn't transpire. So depending on what you're dealing with, that will determine the window of time that you need to give.
Wow, Jacqueline, thank you very much. That's extremely insightful. And what I absolutely love about what you're sharing with us is just your experience and how you've dealt with that. I think over the past 2 years, you've done so many counseling sessions, and I think you've probably seen everything that one can probably see in a session like that. But something that's also stood out to me, and something that I would want to bounce off you, is that principle of corrective disciplinary action versus counseling. And I very often find my clients being in two minds with regards to how they should treat a certain workplace conflict. And my assessment and interpretation has always been that there's a time and a place to counsel, to assist, to have a dialogue, versus somebody that is insubordinate and somebody that has to be reprimanded or corrected via the code of conduct. Would you agree with that? And what are some of your insights on that?
Absolutely, Vaughan. I think if we look at Schedule 8 of the LRA, there's very clear indications of where something is just plain straight gross misconduct, and then don't hesitate to follow that route. I find a counseling very valuable, specifically when we look at a scenario where we're not sure, is this abusive sick leave or is it ill health? Because unfortunately, it has become very easy for people to produce medical certificates. So the certificate is there. And then you're going to follow two different processes. If it's abusive sick leave, you'll follow a misconduct process. If it's ill health incapacity, we know the incapacity process looks different. So then the counseling session is a nice way to try and determine, what am I dealing with? Is there a distinct pattern? If I scrutinize these certificates a bit more, or like the employee then actually said, you know what, I wasn't really sick, I just didn't feel like coming to work. So then the counseling session can just save you time in the long run, so that you make sure you're going to embark on the right process. But if it's clean cut, theft, assault, sexual harassment, then misconduct is your route, according to my views. But it's my view.
Yeah, and what I've also seen is that the employment relationship is laden with heightened emotions. I think over the past 2 years, companies have gone through tremendous pressure, and we can very much see that fuse being much shorter than what it was prior to 2020. The problem with that is, we already see publications of the shortage of skills in our country, the Great Resignation, and our assessment of the workplace is that you need those skills, you need great people to build a great business. And very often we find that companies are hastily, choose a disciplinary process, or choose, a more formal structure to try to deal with the discipline. But what I like about what you're saying is it's less time intensive. It's free for everybody to speak without fearing recourse. And it just gives you that opportunity to, once again, just try to fix that problem before having to resort to very, very serious, formalities like a disciplinary or incapacity inquiry. And, I do think that with a bit of sound mind and, just reflecting on the circumstances, that there might be more opportunities for companies to explore that, rather than to follow our default, which is to issue warnings and to follow disciplinary action. Which is quite interesting. We've got our poll results here, and I'm absolutely blown away here. So the two standout elements in the question, what about workplace conflict is most challenging, was the first one, and I just want to share this with the participants. These two that I'm going to share now have been like a great Springbok match. It's been ahead and back the whole time. So these two stand out. It's the employee or employer failing to take responsibility. And the second one, which is just slightly behind that one, is the heightened emotions. And something that stands out for me, especially with the first one, with the heightened emotions, is we very often have to remind ourselves and our clients that however we deal with a counseling session is so important, because we still have to work together afterwards. We can very much damage the relationship during that session and the prospects of trying to resolve it. That's why having somebody else to mediate, having somebody else to facilitate that process makes it easier, because you can take yourself out of that process and have somebody, assert sound mind to that process, which I've always felt, important. And, very much in heightened emotional type of discussions, it's nice just to have somebody else that can just run the show for you and that can control those tempers. Because the moment that something is said that is disparaging or damaging in that session, it's very difficult to correct it afterwards. And we somehow chink away at that relationship, which is very important to have a continuous employment, contract. And the second one about the employer and the employer failing to take responsibility, I go back to my opening comments, and this is so impactful for me to see these results, that is what our clients are currently seeing problematic in conflict. We have very much seen, and I think I spoke about it last time as well, about the kamikaze effect. We are seeing people that don't care, which is so difficult, because, for a solution or conflict to be resolved, we need participation of both parties. And in my previous session, I shared a little top tip for our clients to say that look out for remorse when you're dealing with harassment. This is once again a top tip that I want to share with my clients and with employees as well. If there's a lack of responsibility or lack of participation, it really signifies that your prospects of success are going to be slim. And we've even seen that with our courts, where they've ruled where an employee fails to participate at the disciplinary inquiry, they essentially forfeit their rights to challenge the process, which is very consistent with what we're finding at this moment. Jacqueline, if I want to ask you, what other workplace issues, conflict issues have you noticed during the facilitation of your counseling sessions?
Vaughan, almost an entitlement. It ties in with what you're saying, where people just don't care. An entitlement of, I'm just expecting to be accommodated. It must be overlooked. It must be okay. I'll come back when I please. I'll send the certificate. So it makes it very difficult. The challenges are so much greater when somebody just don't care. That's very tough. And I think one of the other challenges that we experience, especially if we look at attendance at work, is how easily people obtain medical certificates. It's actually still easy if you deal with a fraudulent certificate. If you phone the doctor and the doctor says, you know what, no, what you sent me, it's not my practice stamp. It's actually not my notepad. I don't know how my number got on this thing. But when the certificate is just issued by a doctor who basically is unethical, who shouldn't be booking this person off, or if there's a high blood pressure issue, not book them off for 5 days, but maybe 1 or 2 days. So that is a big challenge. It makes it very difficult for the employer to also trust the employee. And if we look at one of the sources of the conflict, the relationship one, if there's a breakdown of trust, if I'm constantly suspecting, but you're not being open and honest with me, that is a terrible source of conflict, because we all know the very basis of the employment relationship is trust. If I can't trust you, if I'm always suspecting that you might be coming with a story, it just seeps into every area of that relationship. It almost, you get almost like a distaste in your mouth for that employee. And it's very dangerous when that relationship starts deteriorating. So, if there's a breakdown of trust, the conflict that stems from that, because then the employee also feels it. But jy het altyd jou mes in vir my. You know, you always focusing on me. And then it becomes a back and forth accusatory situation, and it's very negative.
Don't you find it quite bizarre with our employment rate being so high, and the basic principle of employment is that you just have to be at work? Don't you find it quite weird that we are dealing with such an absenteeism-related problem in the South African employment marketplace?
Vaughan, interestingly enough, I was at the CCMA in July and I bumped into a commissioner. I've arbitrated in front of him on multiple occasions, and we were just chatting. The commissioner we were with had a side caucus and I was in the corridor waiting. And I said, he asked, mevrou, is julle besig? And I said, Commissioner, we're busy. It's like, and he said, even at the CCMA, they don't know what's going on, how careless people are. Yes. And he then said, people come there with tears in their eyes, and then suddenly now they realize the job market is very tough. So it's a phenomenon that even at the CCMA, commissioners can't really explain.
Understand. Yeah. In fact, we've had so many cases where the employees have verbally uttered that they just want their notice of dismissal because they want to claim UIF.
Yes.
And you recently had a case where an employee absconded, and once you got to the CCMA, it was noted that the employee wasn't dismissed, but she didn't want to go back to the workplace. She simply just wanted her notice of dismissal to claim UIF. That is concerning because, again, it shows you that there's no real genuine intention of trying to resolve it. And the company still has a function, you know, they still have to fill a seat at the end of the day, which is problematic. Absolutely. Cool. Yes. Thank you. We can continue.
Okay. So at the onset, I said, first and foremost, I'm a lawyer, but then I later qualified as a mediator. And I saw that some of these principles in mediation can be very valuable in employment-related matters. So, let me just make one or two comments on proper mediation. Mediation as a discipline, I find in South Africa, is often used when we're trying to settle divorce matters, maintenance matters, parenting plans. Mediation is very much used in the family law environment. So mediation is a very structured process, although it's informal. It starts off actually with a mediation agreement where before the mediator meets with the parties, they'll actually sign an agreement that will set out the rules for that session. Setting an agenda is also very important, but when we work in the workplace, we usually have one or two topics that we're going to discuss. For example, poor performance or attendance, or there might be a grievance. Then again, it's still the facilitator's role just to say for the record, this is what we're going to address today, even if it's just one topic, and explain to the parties how you're going to go about it. Like I said, I usually start off by saying, this is my role, this is who I am. I'm going to first ask the employer to give me context, and then I'd like to hear from you, employee, what can you share with me that will also give me a better understanding of what you're dealing with. So that's at the onset. Then the parties know what we're going to do. And I also say right at the onset, the purpose of us meeting here today is so that we can leave with a positive plan. I place a big emphasis on a constructive session where we want to leave with some positive plans, action points. What are we going to do to make this better? In explaining your role, I usually say to the parties, I'm here to facilitate the conversation. I'm going to see if I can help you communicate with each other so that we understand the situation. But I might also need to share some technical legal information with you so that you can understand what are the fences that we move within. So you might feel you can be sick as much as you want as long as it's unpaid. I'll tell you, no, it's not the case. You can think as long as you bring a sick certificate, you're safe. I'll tell you, you're not. Employer, you can't fire your employee the first time they came late. So don't in this session say, the next time you're late, I'm going to fire you. You can't say something like that because you can probably not do it depending on the history. All right. focus on interests and rights. Find out what is important to the parties and see how you can then balance those aspects. It's very important from mediation. What is it ideally that the person wants? There was once a mediation where there was a divorce and the ex-wife still wanted access to the family farm. And it was like a deadlock point where the ex-husband said, but what do you still want to come and do there? It's not, you don't belong there anymore. It's past, it's long gone. And a very skilled mediator, I've undergone my training with him, Laurie Gravenstein. He's very, very skilled. And he had a side meeting with her and he said to her, why is it so important to you? What is the interest that you have in still visiting the farm? And she said, my parents are buried in the kerkhof on the farm. All I actually want is I want to be allowed to once a month go and put flowers on the grave there in the kerkhof. And once the husband understood, or the ex-husband, that that's actually all she wanted, deadlock removed. So try and find what is important to the parties. So I find often where employees say to me, but when my child is sick, I'm not going to come to work because my child only wants me. I'm also a mother. Actually, I want to be the one looking after my child when they're sick, but it's then the facilitator's role to explain, yes, your child is very important to you and you feel your child only wants you, but there's a business to run. Isn't there somebody else that you trust that can possibly help you out? Because if we can't make a plan and this pattern continues, you might risk losing your job. What is your why? Your why is your child. Why do you get up and work for your child? Why do you earn a living so that you can look after your child? Surely you don't want to lose the capability. So what plans can we make? And then even provide that employee with a fair amount of time to say, listen, we'll meet in 4 weeks' time. Come back to this table and tell me if you could find anyone or any other plan. A person who can help you when your child is sick. I understand that you want to be there, but we've got to strike the balance, all right? The sweet spot, where can we find the balance, all right? It's very much a balancing act. And again, like commissioners have explained so nicely to me in some of these conciliations, it's like the two parties are there. We must see if we can get them here. And if we can get them there, maybe we can get them there. But little by little, we need to move towards each other to find that sweet spot. Sometimes the employer is going to win a bit more. Sometimes the employee is going to win a bit more. It's not always an exact 50-50, but that is where your legal knowledge as a legal professional or an IR or an ER or an HR professional will pull you through, because then you can say, yes, you've got these rights, but we've got case law who's actually said X, Y, and Z. And that's not something you can quickly go and look up in a book. It's things that you gather as you go along, as you train, as you read, as you deal with cases. All right. I want to make one comment about side meetings. Side meetings is something that I routinely use when I facilitate grievances or mutual separation agreements, where sometimes the employer would say, listen, we've now gone through this disciplinary hearing. We don't really want the risk of a CCMA case. Can you possibly see if you can facilitate a mutual separation agreement? In those instances, there might be information that the employer don't necessarily want to share with the employee, or the employee don't necessarily want to share with the employer. So you will split up, and this is very much a principle from typical mediation, where you will then say to the parties, we're going to have side meetings. And in those side meetings, you can share certain information with me. You can share with me A, B, and C, and then you can tell me You can share A and B with the employer, but not C. So let me give you an example. The employer might say, listen, I'm willing to pay this person 200,000 Rand to just leave. But don't tell them I'm willing to pay them 200,000 Rand. Start with 100,000. Or the employee might tell me, listen, I'm quite willing to go, but I would like a month's notice. I'd like my paid leave. And then I also want to I want the laptop because I must now work from home or start something on my own or whatever. And you know what? You can tell all of that to the employer. Then I can say, listen, the person is actually quite happy with the month's salary. So thank you. I'll take your 100,000 Rand salary. You don't have a choice about the accrued leave. You're going to pay that anyway. And are you willing to throw in the laptop? The laptop is cheaper than another 100,000. Yes. I go back to the joint meeting with both parties and I'll share what I'm allowed to share. But I never share with the employee, oh, you know what? You could actually have asked for 200,000. You don't do that. Okay. So your side meetings is there for you to have a better understanding. What do I have to work with to settle this? But you don't necessarily share everything. Okay. We have spoken about our agenda. I just want to make sure that I haven't missed anything that I wanted to share with you. So your formal mediations is very structured. Your counseling is a little bit less structured, but you'll still just share where am I going with this session that we're having. We spoke about your role. It's quite a complex role. I think now after we've spoken about all of these things, maybe you have a better understanding of what it takes to be a facilitator. There are so many things that you have to keep in mind, that you have to balance, that you have to respond to. And I want to use the example, if we look at interests and rights and finding the sweet spot. If we think about exercise, I cycled very seriously for a long time, many years ago. If I have to get on a bicycle now, I can do 30 kilometers. I can do 60, but I'm going to tap deep into my muscle memory. That's what you want with a facilitator. You want a facilitator who can tap into the muscle memory, tap into previous cases, case law, an article they read, a situation they come across, or a plan that they've previously made, or a plan that an employer previously made that you see, okay, if I adapt that a little bit, it can work in this situation. So you need to be able to think really on your feet. I'm not a, how can I put it? You want to think almost of what you see in the movies. You know, the lawyers get up and they just, still to this day, I prepare my opening statement and I read it into the record. If we do verbal closing arguments, I'll say, Commissioner, I'm going to read my closing argument into the record. In the counseling sessions, it's very much a scenario where you must be able to immediately think of something and immediately speak about it. So it's very important that you use a facilitator with knowledge and skill, immense kennis. You know, you've got to have somebody who's emotionally intelligent as well in those sessions. All right. I want to leave you with 3 last main tools that you can go and use. Reflective listening. I routinely sit in these sessions. The employer tells me we're going to look at the last 6 months and the employee has been absent for 19 days. Okay. Then I'll say to the employee, you know, tell me, do you actually feel that you're healthy enough to work? You know, what are you experiencing? No, I'm healthy. I'm very healthy. Then I'll use reflective listening to say, okay, so the employer told us, if we look at the last 6 months, you've been absent 19 days. That gives us an average of, let's say, I'm not a mathematician, not at all. Let's just thumb suck. It gives us on average 3 days a month. Okay, so on average, a working month has got 21.3 working days, and you only at the office 17, 18 days a month. And this has been going on for 6 months. Do you really want to tell me that you're actually a healthy individual? How old are you? 23, 24, you know? You should not possibly, you know, so you reflect back what the parties has given you. And sometimes that is then like looking in the mirror, the reality check, the penny that will drop. Then that employee thinks, okay, but I'm talking nonsense. You know, my record doesn't reflect as someone who's healthy. All right. So sometimes people also don't remember what they said in a previous session. So if you have a long-standing relationship with your client and you get to repeat a session and have the check-in session with that same employee and you have your notes handy, like what happened yesterday, we work as a team in Nova. So I can pull up the notes of the previous facilitator. So I sit in the session, I say to the employee, okay, so what plans did you make the last time? Were there any commitments made? No, there was nothing like that. It's like, no, we just talked. And I said, well, actually, now that I look at it, I can see that the facilitator actually noted that you committed to bringing the results of the scan, the x-rays. So where is it? No, I'm actually still waiting for the doctor. So I say, okay, well, I see this is dated April. We're now in July, practically August. So when are you going to follow up? And like Vaughan said, taking responsibility. Then I say to that employee, so whose job is it to actually access that report? Would you appreciate it if the employer phones your doctor? No, probably not. You'll be upset if the employer phones the doctor. So when are you going to do this? No, I'll see soon. I said, I'm very sorry. I can't work with soon. I need some commitments. I need some dates and times. So tell me, how much time do you need? A week, a month, 2 weeks? Just tell me. So reflect back on what was said previously, bounce back to the employee what they've given you previously, and see how they respond. Then 2 of my favorites, I had to include them here, whatna and butna. Especially if you have somebody who doesn't want to cooperate, who doesn't want to share, who just is not interested in improving the situation, then I use whatna. And that is when I read them that portion from Grogan and I'll say, you know what? If you don't want to help us understand what you need, if you don't want to share, if your words for the day is finished, and you keep on bringing all of these medical certificates, thank you very much. I will accept that you are too sick to work. So your worst alternative to not reaching an agreement today, just remember this is a typical mediation term. We don't really aim for agreements in counseling, but the principle is the same. The worst alternative to not reaching a plan today is you might end up without a job. And you know what? We call it ill health, incapacity dismissal, and no fault dismissal. It's not your fault. We accept all of these medical certificates, but the law also doesn't require the employer to suck it up indefinitely. So your worst alternative is, and you know what? There's no payout at the end. It's not a retrenchment. There's zero. I cannot tell you how often we then have a check-in session in 6 or 8 weeks' time, zero absence. It's like a miracle cure. Suddenly, the backache, the tonsils, the migraines, the sinus, the allergies, the flu, the chest infections, it all just disappeared when the employee really gets confronted with, I might actually end up without a job, and the employer is allowed to follow this process with me. Best alternative? The best alternative, obviously, is where we can say to the parties, you know, if we can stick to these commitments, then ultimately, it was nice. I want to interrupt myself. A team leader the other day said in a session, you know what? Attendance is actually one of the things that we consider when we promote people to become a floor walker or a performance coach. You know, so if we can stick to these commitments, I want to just tell you, you are a very valued member of the team. And I would love to see you grow into one of these 2 roles. So if we can stick to these commitments that you've made today, then possibly we can look at that promotion, or you can apply for a position that would then result in a promotion. So these tools make it real for the employee. What I want to say as a closing comment, once again, if you partner with a service provider that you can build a relationship with, you also allow your service provider to get to know your environment, the jargon, the needs, the requirements, the intricacies. And then it's also easier for that facilitator to give the real best outcomes in that environment to the employee. And the moment you can make it real, people tend to buy in more easily and to commit more easily. If it's just a hypothetical pie in the sky, it's very difficult to buy into that. For me, it's like cryptocurrency. I want to see the money. Show me the money, you know. I don't want this hypothetical something somewhere in space money or currencies floating. I'm old-fashioned. So also make it real for your employee to show them, if we work together on this, this is what's in it for you. All right. I hope that this was useful. I hope that there's something that you can take from this. I know it's a mouthful and we can spend a lot more time on this, but I hope it wasn't too much information or too overwhelming. And thank you for joining this session.
Jacqueline, thank you very much. Considering the fact that we didn't get any questions, it's almost like that research methodology exam where everybody walks out and thinks, oh goodness, I'm not sure what happened here. So I'm hoping that that's not how our panel, our attendees are feeling today. But fortunately, the session is also recorded. So if there's any of the technical items that you want to revisit, you're welcome to go and check it out, the YouTube channel. And the last thought that I want to leave you with, very often in these counseling sessions, I revert back to that variation clause of the contract. So remember, contract of employment cannot be altered or amended unilaterally. And upon commencement or upon appointment of the employee, there were certain expectations created for the employer. The fact that the employee was suitably qualified, healthy, and suitable for the job. And in all the examples that you've posted to me, it very much shows that there's been a change on either the employee side or on the employer side, that something significantly has changed for the employer. And I often often in these sessions fall back on that principle of variation to say, once this relationship started, this was the understanding for both parties. How has it now changed? And is it reasonable to expect the other party to accept that variation without at least consulting each other and reaching an agreement? And very often that's the aha moment that you've spoken about, that penny effectively dropping for them. So I see we are almost done. We've got about 4 minutes left. Jacqueline, I don't know if you have any final comments or if anybody has any questions, please feel free to ask those. We've got about 4 minutes to answer them for you.
I think I've spoken enough for one morning.
Excellent. Ladies and gentlemen, next month we're going to be dealing with poor performance, especially. We're going to be teaching you how to do that effectively. And we're going to be showing you not only what the law requires, but some of the techniques and the tips that we found is helpful. One of which is exploring that reason, the true reason for the poor performance. Very often we find our clients jumping into a process and we skip that very critical element of that workplace conflict. But please join us next month, and thank you very much for your support in these sessions. We will be posting this on our YouTube channel, as I said. And until then, I hope you have a wonderful weekend, and thank you very much for your support and attendance. I see we don't have any questions, Jacqueline, so thank you very much. I see we are nicely in time, and we can wrap up this day. Keep well, everyone.
Thank you.
Bye-bye.